In a football pool, punters select the outcome of a range of matches to be played each Saturday during the English soccer season. The football pools are still conducted today, and they're quite like the public lottery systems that operate in Australia. In October 1937, Mr. Jones sent two entries into the pools. In those days, they were sent in by mail. The operators of the pools received one of Mr. Jones's entries. Nobody knows what happened to the other. The missing entry was spectacularly successful. Overall, Mr. Jones would have won over £2,137, or more than $250,000 in 2020. Unfortunately, the ticket was never found. Mr. Jones sued the pools for his winnings. It's worth noting at this point that the pools operators made their money by keeping back a portion of the overall pool, so there was no reason at all for them to have just thrown away the ticket. They weren't going to lose any money by paying out on the ticket. It just meant that there was less to divide up for the other winners. So there was no reason for fraud. Now, on the face of it, this arrangement is entirely commercial, and so it should have been enforceable in the courts. However, the entry form included the following. It is a basic condition of the sending in and the acceptance of this coupon that it is intended and agreed that the conduct of the pools shall not be attended by or give rise to any legal relationship, rights or duties or consequences whatsoever, or be legally enforceable or the subject of litigation, but such arrangements, agreements and transactions are binding in honour only. In plain English, the pools operated on the basis of what the court described as a gentleman's agreement. Both sides had agreed that they would not be entitled to enforce the agreement against one another. Justice Atkinson said Mr. Jones had agreed that the money which prima facie became due to him, if that coupon reached them, is not to be the subject of an action at law. There is to be no legal liability to pay. He has got to trust to them, and if something goes wrong, as I say, it is his funeral and not theirs. From this case, we learn that an honour clause can take a commercial agreement and make it unenforceable.